Hi everyone, I am Sagar Soman, a chartered accountant and cross-border wealth strategist. Over the last 20 years, I have advised NRIs on cross-border tax and compliance matters across multiple countries. My work focuses on NRI taxation, FEMA and DTAA frameworks, and I am currently working as an independent consultant with Belong to help you navigate these complexities. You are watching another episode of the Offshore Advantage, where we simplify global finance for the Indian diaspora. If you are an NRI, you've probably seen the headlines recently. Binny Bansal's residential status dispute, Hotbreads owner Mahadevan's case, and suddenly the internet is asking one question. If I am below 182 days in India, how can I still be treated as a resident? Two tribunal disputes have recently pulled residential status back into the spotlight, and the internet has done what it does. It reduced a complex provision to a one line conclusion. Accordingly, the purpose of this video is educational to explain Section 6 and the interpretational issues around the 182-day substitution and treaty tiebreakers. Let's begin with the statutory tests. Residential status is governed by Section 6 of the Income Tax Act. The public thinks there is one test. There are two. First is 182-day test. If you are in India for 182 days or more in the financial year, which is from 1st April to 31st March, you qualify as a resident. Test 2, 60 plus 365 test. If you are in India for 60 days or more in the year and you were in India for 365 days or more in the previous 4 years before that, you still become a resident. These are two alternative tests. If either triggers, you are a resident. This is why the statement less than 182 days means NRI is incomplete. Tax law doesn't only check your current year, it checks your 5-year footprint. So the tax law has a memory. Now there is a relief, and this is where most confusion comes from. In certain cases, the law substitutes the 60-day threshold with 182 days. This is in case an Indian citizen leaves India for the purpose of employment outside India. So 2 points here. This is a substitution, not an exemption. It is purpose based, not location based. So the real question becomes not where you abroad, but did you leave India for the purpose of employment? Now here is a point, and this is where serious disputes happen. People assume employment means only salary. That assumption is too narrow. Judicial thinking over time has examined whether genuine structured professional work, including certain self-employment situations, can also satisfy the underlying intent of the provisions. But here is the catch. Self-employment is easy to claim and hard to prove. So tribunals don't accept it at the face value. And one more important clarification. Tribunals do not test intent directly. They infer intent only from objective conduct and evidence. So the evidence that matters usually includes real work linkage abroad like contracts, invoices, registrations, continuity and substance, foreign tax trail wherever available, whether your work base appears genuinely outside India, whether your conduct matches your claim. This is why the employment substitution is not a day's hack, it is an evidence test. Now, a point people underestimate, and one of the reasons the Hotbreads Mahadevan case became a talking point. Visa category is not a tax law test. Immigration law and tax laws are completely different. But tribunals treat visa category as supporting evidence, not for the legality, but for consistency of narrative. If someone says, I left India for employment, and their travel pattern shows tourist or social visit visas repeatedly, a tribunal may reasonably ask, does this support the stated purpose? Visa type doesn't decide the case, but it can strengthen credibility or weaken it. Now we come to the quietest, most interpretation heavy point. The law tells us when substitution can apply, but it is not explicit on how long it continues. So the debate becomes, if you left India for employment in year 1, can you apply the substitution in later years if employment continues? Important, the statute does not expressly prohibit continued application. That silence is precisely why tribunals examine it year by year. So we must avoid two wrong extremes. It applies only once as a universal claim, or it applies forever as a blanket entitlement. What's more accurate is No automatic carry forward, no automatic denial. Year-wise facts drive the outcome. And this is exactly why Binny Bansal's matter became viral, because the reported reasoning touched this sensitive year linking issue. Now let's apply the framework to Binny Bansal's reported matter carefully. India's stay in financial year 1920 was 141 days. Prior 4-year India stay exceeded 365-day threshold, reported to be far higher. So test 2 60 plus 365 becomes the main trigger, not test 1. The taxpayer attempted to rely on 182-day substitution and the tribunal did not accept it for that year on the reasoning linked to the year of living or year under consideration. This is not just about days, it is about whether the substitution conditions are satisfied and how the year of living logic is applied. The order also mentions that treaty tiebreaker factors were analyzed: permanent home, center of vital interest, habitual abode, etc. And the conclusion reportedly favored India. Remember, treaty residence is not a magic shield. Tiebreaker analysis is evidence heavy and looks at the totality of facts for the year. And finally, on important point here, ITAT rulings can be appealed further. So treat this as a live area of interpretation, not a closed chapter. Now to the second case that became widely discussed, the Hotbreads Mahadevan case. This case is useful because it highlights what tribunals examine while someone claims they were outside India for work purposes. Here, the tribunal relied on travel and residency evidence and examined the nature of overseas travel, including the fact that travel was not consistent with an employment based relocation narrative. The educational takeaway for NRIs is straightforward. If you are claiming the substitution, your story must be consistent across purpose of leaving, evidence of work abroad, continuity, immigration pattern as a supporting indicator. Now let's turn this into a checklist that prevents surprises. Always run both tests 182 and 60 plus 365. If relying on employment substitution, build evidence. Employment, professional linkage, continuity, foreign base indicators, supporting immigration consistency. Treaty TRC helps but doesn't override Section 6. After residency, check ROR versus RNOR. Taxability scope changes accordingly. And my strongest advice, don't plan residency on WhatsApp forwards, plan it like compliance. Where the law is clear, follow it strictly. Where the law is silent, expect interpretation. And where interpretation exists, documentation matters more than assumptions. This is not about structuring facts, it is about understanding how existing facts are examined. And this is why this topic keeps returning. In tax law, certainty does not come from counting days alone, it comes from aligning conduct, continuity, and evidence year after year.